Hi, everybody. My name is Sarah Szymanski, and I am the Adult Services Supervisor at the Mount Airy branch of the Carroll County Public Library. First, I would like to apologize for our technical difficulties, and I appreciate anybody who's been hanging in there. Tonight, we are going to have a presentation from Keith Merkey. He's the Education and Outreach Associate for the Maryland Commission on Civil Rights, and this evening he's going to be speaking about fair housing and giving us an overview of Maryland fair housing law.
Great. Welcome, everybody. My name is Keith Merkey, and I am the Education Outreach Associate at the Maryland Commission on Civil Rights. And tonight we're going to talk about fair housing. We're going to look at an overview of our Maryland fair housing law. April was Fair Housing Month, but we're continuing it through the months of May and June and providing information about what the law is in the state of Maryland when it comes down to your rights in housing. I've been with the agency for about 20 years. And so what we're going to do is I'm going to go through, first of all, what we do and then launch right into fair housing. So if you have any questions along the way, put it in the comment box. And then when I finish up, I'll go to the comments and we'll take a look and I'll try to answer your questions. So let's get started. So the mission of the Maryland Commission on Civil Rights, next, is to make sure that all persons have equal opportunity in the state of Maryland against discrimination and harassment in such areas as employment, public accommodations, housing. Our newest is health services and commercial non-discrimination, which is subcontracts with the state. We also provide educational and outreach services that we share to make sure people know these laws. And we want to promote and improve civil rights in the state of Maryland. Next. So once again, I mentioned these are the 5 main areas that we protect under Title 20, the annotated code of the state of Maryland, Title 20 as well as Title 19. So employment would include everything from how jobs are advertised to what kind of interview questions you're asked, how you're treated at work through benefits, but also it would include when you decide to leave or if you were let go from work. So we cover the entire gamut of employment. Under that falls sexual harassment as well as different forms of harassment and discrimination. Housing, which we're going to talk about tonight, will run the gamut from mortgage rates all the way through if you're allowed to see a place, if you're allowed to rent, and how we're treated in real estate transactions. Public accommodations is access to any public facility or service. If it is considered public, if you're advertised as public, it must be open to all persons. That's why the public library is public in their name. They must be open to all persons. Health services, our newest, deals with access to facilities as well as health services. And commercial non-discrimination deals with companies or businesses that subcontract with state agencies, and we monitor that. Next. So under housing, we have specific protected classes and protections. So race, gender or sex, and this is actually where we also find sexual harassment, which we will talk a little bit about tonight. Next. And also last names and things like that. Religion is your practice of religion as well as your non-practice of religion. Color is the tone of your skin. So it's not really like color, but is the tonality, so light or dark. Marital status, married, single, widowed, divorced. Sexual orientation says you cannot discriminate based on a person's heterosexuality, bisexuality, or homosexuality, nor can you make assumptions about treat people differently because you think you know, making an assumption about. Disability, which we'll talk a little bit more in depth about, deals with both mental and physical. So mental could be mental illness, learning disabilities, intellectual disabilities, and physical, sight, mobility, hearing, medical conditions, pregnancy would all fall into that. Gender identity is related to our gender identity, deals with any gender-related identity, appearance, behavior that might actually be different from the gender that a person was assigned at birth. And it also is held as a sincerely held part of their identity and what they know and believe about themselves. It's not about us making judgments about someone's gender identity. It's what a person relates to us as their identity. Familial status is found only in housing, and this is the presence of children. So, and we'll talk more about that as well, both familial status and disability. Our newest one is source of income, which we're going to talk more about as well. That's just been added as of October as a protected class. Next. So before we talk about a little bit more in depth, let's talk about if a person files. So there are always deadlines for everything we do. So complaints of employment and public accommodation discrimination has to be filed within 6 months of the alleged unlawful incident. It's 2 years for employment charges which allege harassment. So 6 months for discrimination, 2 years for harassment, which has increased. We've had that increase this year. And finally, for housing, it must be filed within 1 year of the alleged unlawful incident. So you have 1 year to file from the time that it happened. Sometimes it takes time for people to understand what's happening and finally maybe working up the courage to file. Housing is very difficult because unlike employment, it is probably easier to find a job than it is to find a new place to live. And so that's why it is important for us to understand the fear that people have sometimes in complaining or bringing a charge because they're afraid they're going to lose where they live and their family will be impacted quickly. Next. So our main functions at our office: intake. We receive a complaint and we assess whether it falls under our law. Does it fall within our timeliness? Is it one of our protected classes? If it's certified, then it moves up to investigation, where our investigators will take a look at the case. They will contact the party, the respondent's party, the respondent from the complainant side, letting them know of the allegation, asking for documents and information so they can assess it. We'll go through a fact-finding conference. And along the way, we encourage conciliation and negotiation along the ways, knowing that when you have that much, you have more power that way in deciding what happens. There are times that we have to go to the litigation department, our legal department, where they assist the investigators in understanding and interpreting the law around cases. That they help us in education, as well as represent us in any kind of legal things that we have to do in the state. And of course, our unit that I work under is the Education and Outreach Unit. Next. So, since it's hard for me to respond, I put this up there for us just to understand. Fair housing predominantly deals with persons who are renters. That is false. That is an assumption that people make. It's really dealing with people trying to find a rental and people treating them badly because of rental. No, our fair housing deals not only with renters, but also sellers, real estate agents, mortgage lenders, anybody within the real estate world, our law covers. And so down to advertising. And that is something that people forget. If you've ever noticed, if you're as old as I am, and I'm not saying that I'm ancient, but the fact is I remember when ads in the paper and ads in apartment guides definitely kind of steered us to specific areas. So you would have images of families in an apartment complex, and if you were, for example, an older adult or a person who doesn't want to be around children, you go, oh, there are going to be children there, so I'm not going to even look there. So it kind of steers you away from specific. Same way if you had an image where there are no children there, and it's a specific color or race of people, you're like, oh, I'm not supposed to go there. It will steer us to specific ones when really what you're renting is a building, not people. All these people tend to be actors. You are renting a place to live that you can afford. You're not renting those people. Next. So one of the things I ask people all the time is, have you seen this symbol? This is actually the fair housing symbol that's been used for many years. Landlords, banks, real estate agents, and others within the real estate world use it to show that they're not going to discriminate against you or your family when you're looking for a home. So I always say, look for those symbols. Symbols are very important. Look for the symbols. You may see them on brochures. You might see them on signs. You might see them in window signs. If you go to a real estate agency, you'll see, equal housing opportunity, many times some logo somewhere within that office. Next. So we also want to talk about what is fair housing. So what this is that you and your family, or you as an individual, have equal opportunity to choose where you want to live without being discriminated against or treated differently based on one of our protected classes. This is something that has not been around forever. Just within the last, say, 30 to 35 years. Prior to that, people were constantly, forced not to be in different places. Baltimore was a center of a lot of housing discrimination. They invented what is called redlining, where neighborhoods became even more segregated than they were before, around 1904, around turn of the last century. Baltimore's famous for that. Baltimore went from looking like a spotted leopard of both, African Americans and whites living around each other all the time, to looking more like a zebra. There had been a law that had been passed but was found illegal by the Supreme Court, but it was in play for several years. The law in Baltimore was that if you lived on a street that was predominantly white, you could only sell to white people. If you lived on a street that is predominantly black, you could only sell to black people. So the city law actually was telling you who you could sell to. We also had covenants in place that, for example, neighborhoods that would not allow you to sell your home to not only African Americans, but Jews and sometimes Catholics. So they had covenants in place that forbid you as a homeowner to sell to any of those groups. So those are things that vestiges still exist for us today, even though they may have been made illegal by sometimes the 60s and the 70s, or they were not being used anymore, especially by the 80s, but the vestiges still remain. And on some deeds, you'll see them. Next. So we're going to look at tonight some of the unlawful discriminatory practices, the protected classes, persons with disabilities, and sexual harassment as it relates to housing. Next. This is something that people also assume that they can do. An apartment complex can require that families with children must be placed in apartments on lower floors of their buildings. False. Many times they'll use it as an excuse to say we want to keep children safe. The people that need to keep your children safe is you. And also the fact it really is a pretext. So what will happen is if you have an apartment complex and all of the apartments on the lower floors are already occupied, and someone with a family comes in and they need an apartment, you have 12 apartments, but they're all on the second or third floors, and you say, I'm sorry, but we don't rent to people with children on second and third floors. They must be on lower floors, and we don't have any available. It's still a denial, and it is illegal to do that. It's almost like segregation. So you have a building that may have children in it, and we only put people with children in those buildings. It's like segregation. You cannot segregate according to families, etc. So that is a false. Next. So what we're going to talk about is unlawful discriminatory practices. So let's go to the next slide. Certain practice, see that these are the unlawful discriminatory practices, and many things you might know this. Denying or refusing to rent, denying or refusing to sell, treating applicants differently, just on the surface, treating applicants differently in terms and conditions of any real estate transaction, lending, any kind of loans or mortgages, or advertising with illegal preferences. So we talked a little bit about that. Next. Some of the other practices, providing false information about availability. You call for an apartment, for example, and they say, oh, we have 2 available, we'd love for you to come in and look at it. And you show up and they look at you and their assumptions about what you are kicks in and they go, oh, I'm sorry, but we don't have any apartments available, even though they still have 2 available. That is providing false information about availability, and that is one of the unlawful discriminatory practices. And there are ways to test this. We have what they call testing, where people go in and test to see if someone's lying about whether an apartment is available. They do this in employment as well, saying a job is not available when it really is. Another one is harassing or intimidating people from exercising their rights in housing. So scaring people off so they wouldn't move into your neighborhood, making threats, all of that harassing, intimidating behavior may come from neighbors or people that would be living next to you. Block busting, when and this happened a lot in the 60s and 70s, where unscrupulous real estate people would come in and say, oh, you know, this certain group is moving in and you're going to lose the value on your house, but we will purchase your house from you to help you get out so you save some money. And so then the people sell their house, and then those persons resell those houses at a higher rate to the people moving in. And so it's that block busting, destroying neighborhoods. Another one is imposing different terms of financing because of a particular class. So there have been banks and lenders that have charged women and people of color a higher interest rate without checking credit versus the interest rate that a person of a white male may get. Also denying or applying different terms for real estate services, such as brokering or multiple listing. So they may not say, oh, well, that multiple listing is not available for you, but any kind of those applying different terms that someone else would have. Okay, next. So we'll go next to the next one. We talked about our protected classes. So now let's look at the federal protected classes. So as you know, there are laws on 3 different levels. You have federal law, which is all across the United States. Then you have your state law, which Maryland Commission on Civil Rights will enforce. And then, of course, in many areas, you have your local laws. Some counties have very stringent local laws when it comes to human relations, and some do not. If they do not, then our law will always be there to protect. But some counties like Prince George's, Montgomery, Howard, Baltimore City, Baltimore County have more protections than, for example, than even the state or the federal does. So all of them have to have these basic 7 to begin with. Race, color, religion, sex. They call it handicap in federal law. We call it disability. Familial status and national origin. Those 7 are found across the United States. So if you have a state law, that's going to include these 7, plus if you have a local law, it'll be these 7 plus state plus whatever else. So next, please. So for example, we have those 7 in Maryland, but we also have added marital status, sexual orientation, gender identity, and source of income. Some local may be occupation, political affiliation, or even personal appearance. So those are some other that might be broader. You might find those in Howard County or Montgomery or Prince George's. Sometimes veteran status would be another one, but that's not a state law, but that's going to be only local for your, for example, your county. So those are some of the different coverages that you can get. And sometimes we added source of income this past year. Doesn't mean that sometime we're not going to add, for example, criminal record or something like that may come from the grassroots, and we support it in adding it to our law. Next. So we're going to talk a little bit about families with children. Now, what's interesting is that in order for the state commission to add families with children as a protected class, we had to remove age as a protected class, because what was happening, apartment complexes and sometimes even condos were saying we only serve adult communities. So it was becoming more and more difficult to find a place for families with children to rent. So in order to add families with children, familial status, we had to make exemptions. So families with children include parents and persons with legal custody of children under 18 living with a parent, Children that has a designee by state or local law, someone that might not have, for example, living parents or whatever, or a person who is pregnant or getting custody of a child under 18, persons who are maybe dealing with foster care, persons who may be doing adoption. So the exemptions, and you might know some of these if you have retirement homes or retirement villages around you. And these are designated by federal and state laws. So someone can't just say, oh, I'm senior housing. You have to be designated as such by federal and state. So 2 exemptions. First one is solely occupied by 62 or older persons. So everybody in that unit has to be 62 or older. If anything changes and there's someone, for example, if you're 67 and you inherit grandchildren because, for example, your daughter who's been raised children no longer can care for them. They can't live with you. Everyone has to be 62 or older. If not, you will have to leave. For that reason, there's another exemption level, and that's 80% of the units have to be occupied by 55 and older. So you have 62 and older housing, which is designated, or 55 and older designation, which means 80% of those units have to be occupied by a person 55 or older. That 20% allows space. So if someone, for example, is 58 and their spouse is 53 and the 58-year-old dies, the 53-year-old doesn't have to move out because they fall within a 20%. They have 20% of their units are available for people that are not 55 or older. But also we run into the collateral issue, which is about occupancy standards. And sometimes people will say, I'm sorry, but I can't rent to you. You have 4 children. You will have to rent a 5-bedroom apartment. No, you don't. We look at, the size of the apartment, square footage, the rooms that could be designated as bedrooms. Where do you put, sometimes people will say, well, you've got to have a bedroom separate for boys and girls. And there are different occupancy standards when you talk about foster care than when you're talking about renting as a family. So that's some of the other issues around occupancy, and those are very specific. So if you find an issue with that, I would say give us a call and we would talk you through that. Next. So that was children. Now we're going to talk about the new one, the source of income. So this is relatively new. Not to say that we haven't had issues with this over the years and some of our major issues, but there was no way that we could deal with it because it wasn't necessarily illegal yet. So when we talk about a person's source of income, it is any lawful source of money that is paid both directly or indirectly to or on behalf of the renter or buyer of the housing. And the way that's written is like, for example, if I give you a check, my rent. Or if, for example, you're receiving a stipend or a supplemental check or assistance from the federal state government, or a nonprofit agency, for example, that will pay your rent, as long as it is a legal source and it's paid directly or indirectly on behalf of that renter or buyer. It is a legal source of income. That includes a lawful profession, occupation, or job. And the key is lawful. Sometimes people will say to us, it might be like, well, what about drug dealers? Not a legal source of income. It is not a lawful profession. It has to be a lawful profession, occupation, or job. It includes any government or private assistance, grants, loans, or rental assistance programs, which includes any low-income housing assistance certificates or vouchers that have been issued under the United States Housing Act of 1937, which is our Section 8 housing. A gift, an inheritance, a pension, an annuity, alimony, child support, and any other consideration or benefit. So if you have those things coming in, those are legal sources of money. Or even if you have a sale or pledge of a property or an interest in a property. For example, if you're selling a family home, you have to split the proceeds with a sibling or whatever, but you're going to get this amount of money. That is a pledge or interest in a property, and those are legal. Next. So when we talk about the source of income, there are exemptions. If it's an owner-occupied building, so if you own a building and you have an apartment and there are 2 other apartments in that building, you can be exempt from that law, from that ruling. or if you're in over 5 units or less. But once you start having apartment complexes, you're going to have way more than 5 units or less or more. You'll have way more than 5. So you won't be exempt. So those are the 2 exemptions that were put into place. So next, and we'll go next again to the next exemptions. So for example, if you are selling your house and it's a single family dwelling, you're exempt, whether you rent or sell it, if it's sold, number one, without using any kind of sale or rental facility or services. So as long as you don't use a real estate broker, agent, or salesperson, any agents of them, or any person that's in the business of selling or renting dwellings, or an agent of a person in business and selling. If you don't use any kind of professional services for the rental or sale of a family dwelling, you're exempt. And when you do your publication, post your mailing about your housing, as long as you do not advertise a discriminatory intent. So saying things like, I only rent to single white Christians. So you're advertising an intent, which could be illegal. But if you're saying this house is for rent, it's 3 bedrooms with a bath, a dining room, living room, and a kitchen with a basement. This is what it is. Quiet neighborhood, not far from shopping, those kind of things. But if you start describing the people that you want in it, that's where you may run into problems. So you make sure that any publication, posting, mailings is not in violation of our statute. So as long as you do that, you're exempt. If you advertise an intent, all of a sudden the law comes into play. Next. Now, even though we're talking about exemptions, the prohibitions in this against discrimination based on source of income does not prohibit a person from determining an ability for a buyer or a renter to pay the purchase price or pay rent. And you want to do that by verifying in a commercially reasonable and non-discriminatory manner the source and amount of income or credit worthiness of the potential buyer or renter. We don't prohibit people from making sure that they can afford to pay the monthly rent or pay the mortgage. Cannot prevent a person from refusing to consider income derived from criminal activity. Just a reiteration of what I said, must be legal income. Or prohibit a person from determining within accordance of any kind of applicable federal and state laws the ability of a potential buyer to repay a mortgage loan. So if you go through what is available to check and make sure that someone can actually repay the mortgage, you may check it by credit references, credit ratings, all of that to make sure that someone can repay it. That is not prohibited. You're allowed to do that. Next. Another question. It is illegal to deny the rental of an apartment to persons because they're unmarried. True. Now, we have a history of people being denied housing because of a perception of what kind of people they are. My parents were, for example, could not find an apartment in the area I grew up in the mountains of Virginia, because my mother had been married before and divorced, and this was the 50s. So when being from a small area, people knew each other, and say they knew my mother had been married, divorced, and married to my father, and then married to my father. And because they perceived divorced people as not good people, especially divorced women, not divorced men, but divorced women, then they were refused rentals. It's illegal to do that now because of marital status, but that happened a lot in many areas. Next. So the persons with disabilities, we're going to talk a little bit more about them. We did source of income, and we talked about families with children. This is a much broader discussion because this is the one of the top, or probably the top form of discrimination that we have within housing is usually for persons with disabilities. It's based on disabilities. We get more cases because of this versus others that may have been at one time, but we usually lead with for persons with disabilities. Next. So it's unlawful to discriminate in sales because of disability. That means make unavailable or deny a dwelling, saying we don't, it's not available, we don't want you. Terms and conditions and privileges of that. So privileges include things like, and if there's any community buildings, facilities that are open to the public, that could also include things like sidewalks and parking facilities, playgrounds, pools, any kind of public rooms. And also it's unlawful to discriminate based on provision of services or facilities in connection with the dwelling. Or there's also prohibitions against inquiring of an individual's disability, but we have there's a caveat to that, and we'll talk through that a little bit. Next. So when we look at we have to define what a person with a disability is, because there's a lot of information out there, and when it comes to housing, it can be very specific. It includes a physical or mental disability which substantially limits one or more major life activities. And there are lots of major life activity, like mobility, deafness, blindness, breathing, walking, thinking. All of those are major life activities, taking care of oneself. Or they have a record of such a disability, which include like alcoholism or past drug addiction. You can have a record of drug addiction being a disability, but once again, it's a record of. It doesn't, if you're a current drug user, you would not fall as a protection under this. It's you have a past drug addiction. Or sometimes people are regarded as being disabled, like HIV positive, because of it substantially limits one or more major life activities, though persons who are HIV positive can live a pretty full life. But you're regarded as being disabled. And there are other cases as well. For example, you had major heart attack, or you're a survivor of cancer. You're still regarded, you may be regarded as being disabled, though you may not see yourself as disabled. Next. So persons who aren't covered, persons with disabilities, and they may have disabilities, but they're not covered. Juvenile offenders are not covered. Sex offenders, even though we know that many of the sexual offenses are actually mental illnesses, they're not protected under housing law. Current illegal drug users, persons who pose a threat to the health and safety of others, because there are some forms, and I worked with persons with mental illness before, and the majority of people with mental illness are not a danger to other people or the health of other people. But there are some that are. And so anybody that poses a threat is, we're not covered. Or if they pose a threat of substantial physical damage to the property and may destroy the property in some way. Next. So we talk about two things that a person with a disability might require and has the right to ask about. One is reasonable modification, and one is reasonable accommodation. So we'll talk first about modification. So think of the word modification. It comes from the word modify, which means it's a physical thing that we do. So it's the modification of facilities. So it is unlawful to refuse to permit, at the expense of the person with a disability, of existing premises occupied or to be occupied by the individual. So for example, lowering a threshold in the door, widening doors, putting a ramp in, putting grab bars in the bathroom, lowering kitchen cabinets down so that you can access it if you're in a wheelchair. You cannot refuse someone to do that, but it's at the expense of the person with a disability. So modification is at the expense of a person with a disability. It is not the housing provider's expense. It is up to the person with a disability. And if it's a rental, the tenant agrees at the tenant's expense to restore the interior of the building, accepting reasonable wear and tear. Now, but there are some things you wouldn't normally leave. Look, so a person leaves it, they're not going to remove grab bars. Those are useful in bathrooms for anybody. You're not going to, if you've widened the doors for wheelchairs, you're not going to bring the doors back. But you might raise the kitchen cabinets back up or reinstall certain cabinets. What some tenants as well as some landlords do, they put some of the money in escrow so that when a tenant does leave, there is money there to help restore the interior of the dwelling. Now, if it's reasonable wear and tear like carpet, paint, that's reasonable wear and tear. That should not be, that's not the expense of the tenant to restore that. Okay, next. So that was modification. We're correcting a facility. So modification for other places like common areas, that's up to the housing provider, making sure there are sidewalks and curb cuts and parking facilities and parking, for example, if they offer parking, you've got to have a certain amount of disability, parking for persons with disability, access to common areas and access to buildings that are supposed to be for everybody. Like I said, like the pool building or the pool itself, public playgrounds, etc. Now, accommodation deals with things like rules, policies, practices, and services. So we must make a reasonable accommodation in these, the rules and policies, practices, and services. Next. So looking at, for example, some of the accommodations that are granted, so we're talking about services and policies, you can have an assigned accessible parking space. I know people say, oh, I can't give it because then everybody will want one. Well, it's a first come, first serve. So if someone comes to you and says, look, I have a disability tag, I have a person with a disability, you know that. I have difficulty walking long distances. I have difficulty getting in and out. So I'm asking if you could assign a space closer to the door that leads to my condo or the door that leads to my townhome or whatever. You can grant that. It may be an exception to the rule requiring tenants to bring rent personally to the office. Like you may say, well, you can mail it, or you can have someone bring it to the office for you. Whatever, but you can have an exception to that rule. You can come up with another accommodation that would work. And an exception to the no pet policy for emotionally disabled tenant. So this is a real key, and I can't mention it more. I will mention it more and more. If a person has an assistance or service animal, they are not pets. So the concept of it's a no pet policy, well, I'm not covered by that anyway because it's not a pet. It's a working animal, which is not a pet. So you can have exemptions to that. Next, so we're going to talk about assistance animals, because there's a difference between assistance and service animals. An assistance animal is an animal that works, provides assistance, or performs tasks for the benefit of a person with a disability that can alleviate one or more identified effects of a person's disability. An assistance animal is not a pet. Next. So we have types of assistance animals. Two would be that we consider service, would be hearing dogs, which alert their handlers to things like alarms, doorbells, and signals, or guide dogs, those help who are blind or visually impaired. Those are ones that we probably have seen more out in public. But there are others, seizure alert animals. So you may have heard of some of these that may recognize when an impending seizure is coming, and what they may do is put their body up against their person that will help them. Like if they need to come to the floor or slump to the floor, the dog or animal is there to make sure that they can do that. It might also be alerting another person if there's another person there that something's going on, or to guard them when they're having a seizure. So to make sure they're protected. Next. Psychiatric service animals, which helps handlers manage mental and emotional disabilities by, for example, interrupting self-harming behaviors, reminding them to take medication, checking spaces for intruders, providing calming pressure during anxiety or panic attacks. And these can be more than just dogs. Allergen alert animals may let the people know of foods or substances. I was just reading an article about a man with cerebral palsy that has I think it's a capuchin monkey. And because the monkey's hands are very similar to human hands, that they can open bottles, like water bottles, they can open medication bottles, they can open doors, they can pick up things that dogs may not be able to help with. So there are a lot of variety of animals that can assist a person in doing their tasks. They can be trained, they can be taught, they help work. They're working animals, they are not pets. Next. So the key points, they're not pets. I will remind you multiple times, they are not pets. They do include emotional support animals, which are the animals that provide comfort or safety. And they can be animals that are specifically trained or animals that just do work and perform tasks for a person with a disability. So those are the major points. So when a person asks for an accommodation, next, the Fair Housing Act requires that a housing provider to allow reasonable accommodation to involve assistance animal in a situation that would meet these conditions. So the request is made to the housing provider by or for a person with a disability. So there's a request made. The request, so when we request, it can be supported by reliable disability-related information. So if the disability and the disability-related need for the animal are not apparent. So if it's not obvious as to the disability and how the assistance animal and the disability are related, you can ask for some more information. And so you can ask for, it could be information from a doctor, it could be from a support group, it could be from a third party that would know, it could be from the person that has the animal. So there are multiple ways you can get the information. However, if it's a parent, you cannot ask any more questions. If it's a parent, they're a person walking with dark glasses and has a cane, and they're saying, I need to have an assistance dog with me, a service dog, and that's pretty obvious. You don't need to ask for any further documentation. It's only if it's not obvious and you're not sure of the connection. So the other thing is the housing provider has not demonstrated that by granting the request, it would impose an undue financial and administrative burden on the housing provider by saying, we can't do it, and they have to prove that it's going to be a financial burden or administrative burden. We will want to look at books and we want to know how much money. So it'll have to be go through kind of an audit. Or the request would fundamentally alter the very nature or essential nature of the housing provider's operations. It's like asking the housing provider to do something that is not within the purview of housing itself. Like having the housing provider, the staff of the housing provider help you pick out clothes. That's not their job. Their job is to provide housing. So if they can prove that it's outside of it, if it's causing an undue financial administrative hardship, or if the specific assistance animal in question would pose a direct threat to the health or safety of others, despite any other reasonable accommodations that could eliminate or reduce the threat. So once again, they have to provide information and prove this. Or the request would not result in a significant physical damage to the property of others, despite any reasonable accommodations that would eliminate or reduce that physical damage. There will be people that say, oh, well, what if someone needs the assistance animal is a baby elephant? Probably not going to happen. But people will go that, well, would it cause substantial physical damage in a second floor apartment? Probably yes. But we know that those are things that people throw up instead of really talking about persons who really use assistance animals and the kind that they use and how would it cause the physical damage. You need to show proof of that. How would it show? Where do you have the, give me the studies. Next. So some examples may include a request to live with an assistance animal at a property where a housing provider has a no pets policy. So that's an accommodation that can be granted, or a request to waive a pet deposit fee or other rule as to an assistance animal. And I keep going back to this. They're not pets, so they don't need a pet deposit because it's an assistance animal. So that you cannot be charged extra for that because they are not a pet. Next. So some of those accommodations denied, like I said, if it alters, for example, asking for daily trash pickup by the housing provider. They're not the garbage collection. That's not their major function. Their function to provide housing. Now, some may do that, and that might be a perk, or it might be something that they just offer that's different than you requesting it for trash pickup. Or requesting for a housing provider to walk a service dog. That is not their job to take care or walk a service dog. Or requesting the provider transport tenants to and from grocery store and do shopping. Some places do. I noticed I've worked with people with like Oakcrest, which is one of our retirement homes, and they do provide some transportation so the tenants can get out, get to the grocery store and do some shopping, but it's a choice they make as a part of their program. But to request it when it's not a part of the program, they can deny that. Next. So we talked about the inquiries about a person with disability. Now, the thing is, many times people just want to know what the disability is because they're nosy. They just want to know. But when it talks about a person with a disability, you are not allowed inquiries for obvious disabilities, except if the accommodation they're asking for is not obvious. Like it doesn't, like if a person is, for example, is in a wheelchair, but they're asking for something that is not obvious. Like they're asking for an accommodation for sound, and say I need my everything to flash when someone rings the doorbell. I like for my lights to flash, and you're like, well, so you have to ask. So how is that connected to your disability? So unless it's not obvious. So if it's obvious, like say, I'm in a wheelchair and I need to have a threshold on my door lowered because I can't get in, I can't get over the threshold. Well, that's obvious. You might inquire into the severity of a disability to assess whether the applicant for housing is limited to persons with disabilities. So if your housing is limited to persons with disabilities, you might inquire as to the severity of that disability. So see if they're actually can access that housing. And you are restricted to threshold questions. How are they connected? How is the accommodation connected to the disability? So that it might help them assess other forms of accommodations they could do. For example, you may ask for a specific accommodation, but they may say, tell us more about why you need it. Can you tell me how it's connected? And they may have another way to provide an accommodation that might not be the way you see it. So it's a way of ascertaining the best way to provide an accommodation. That's why you are restricted to threshold questions and not any question I want to ask about your disability. Next, sexual harassment. And this we've added in housing specifically because we've seen cases, especially in like housing authorities or housing complexes, apartment buildings. So next. So sexual harassment is defined as unwelcome sexual advances, verbal or physical conduct directed toward an individual, such as a tenant. And there are two types: quid pro quo, which is this for that. It's a Latin for this for that. I'll give you something if you give me something. And hostile environment. And so next, quid pro quo is whenever a housing provider or his or her employee, agent, or contractor conditions any access to or retention of housing or housing-related services or transactions on a per victim's submission to sexual conduct. So we've had cases where a maintenance person would say, "Look, if you want that fixed, then then you need to have sex with me. I'll fix it. As long as you have sex with me, I'll make sure your apartment is always fixed. But if you don't, then I won't fix anything." So it's that quid pro quo. Next. Now, hostile environment is different. So it's when a housing provider or his or her employee, agent, contractor, or in some circumstances another tenant, engages in sexual behavior of such a severity or pervasiveness that it alters the terms and conditions of tenancy. And what happens is it results in an environment that is not only intimidating, but hostile, offensive, and otherwise significantly less desirable. And it could be endangering, where someone that has a key to your apartment comes into your apartment while you're taking a shower, or a tenant that hangs around your apartment. So every time you leave, they go, "Hey, how are you doing? You're so pretty today." And every time you pull up from work and they're waiting, or you've got to go to work, they're waiting. So anything like that becomes hostile and makes it intimidating, hostile, or offensive. And so they must learn to deal with that. So the housing provider is held accountable for not only quid pro quo of their staff, but also hostile environment, sexual harassment. It's up to them to correct it. So when you report it, it must be corrected. and it must be corrected to the best way that they can. And that means making sure everyone's aware of what's going on, making sure that people know where to file, who do you talk to. And I think this is something we're so used to doing in employment, but we're not used to doing this in housing. So housing providers that are especially rental buildings and things like that should have notices posted, letting people know this is what, this is the law and this is what is not, we don't allow this in our housing space. So these are some resources that you might avail yourself of. They all have information on housing as well as us, as well as our office. But these are some other, especially for persons who might need some legal assistance. Maryland Legal Aid is really great for that. Information about certain programs, Department of Housing and Community Development, as well as our new Fair Housing and Action Center, which deals with a lot of landlord disputes and things like tenant and landlord disputes. So that's a really great resource. Do you have any questions? And I'm going to put up our information. And so I'm sorry, I've been going so fast. I Sarah may have forgot to tell you. Have you moved on to resources? And then questions. So, and I'll just leave up the very last slide and I will come back. So do we have any questions? Okay, I see Susan. I was surprised that age was not included. And I did cover a little bit, but age, because they added familial status, which means the presence of children, age was pulled out because many older persons feel, don't necessarily want to be around a lot of children. They've already raised their children. And so they want to be in a place where there's maybe not huge numbers of children that are not related to them. That's why they created the 62 and older, 55 and older housing. So they're given exemptions. So it didn't really eradicate age. It just gave them exemptions so they could fall into that. Anybody else have any other questions? Just see that one. Okay, I am going to, so thank you so much. I appreciate it. Okay, Sarah's back on.
Hey, everybody. I just wanted to say thank you so much for attending our program, and thank you to Keith for that very informational program and for taking the time to share all of that information with us. If you didn't get any of his information and you need to, you can always contact the library. Again, I'm at the Mount Airy branch. You can contact me, or
Thank you so much.
Or you can contact any one of the branches and we'll be happy to help you out.
Thank you, Sarah. Thank you, Shelby. Thank you, Lisa. I appreciate it. Thank you, everybody that attended. And if you have any need, I will make sure Sarah has the PowerPoint, so she has the information on that. So you can always contact Sarah Szymanski at the Carroll County Public Library, and she has my information. Thank you all so much.
Thank you.